right. Nice holiday weekend. We'll wait for all of you to join us, and then we will get started shortly. All right, good evening, everybody. This is Naif Mubarak with Mubarak Law. We are doing this week's Facebook Live. And before we bring on Attorney Caminero from our office, as always, tradition, I'm going to go ahead and share some updates with you guys. And then we're going to go over several topics today. There's been huge amounts of updates and changes that I think are going to be really important for you all to hear about today. And if you have any questions that you want us to address, we will do our best to do so. Go ahead and leave them in the comment section, and we'll do our best to answer those questions for you, okay? So, again, I'm Naif Mubarak. Last week we were here and we announced our new of counsel, Attorney Ben Hunter, who is going to offer services of wills, trust, and estates planning for our clients. And I thought that this was really informative video. So if you missed last week, please take the time to go back and hear what he had to say. I, for one, had no idea that if your family members or your spouse was not a US citizen, you can get hit with some serious taxes, estate taxes, if you don't have the proper document in place. So that was last week's live. Go back and check that out. This week, we do have some updates. We sent out our newsletter yesterday. So if you did not receive it and you would like our monthly newsletter, please subscribe. You can do so by emailing me or Jessica. There you can find case results. We had a couple of smiling families in yesterday's newsletter. So it's a really good way to stay up to speed on all the developments in immigration law and in personal injury, and even wills, trust, and estates. So we do like to mention some good news. And last week, some good news for us was the Supreme Court DACA decisions. Last week, the Supreme Court ruled that the way this current administration chose to unwind the DACA program, they found that it was unlawful. And we're going to talk about what that means for DACA applicants, first time and renewals later in the show. But for me, this is some of the good news. And also the Supreme Court ruled on the women's right to choose, the controversial law from Louisiana, and also the LGBTQ rights for employers. They can't terminate anybody based on their orientation. So I'm going to go ahead and bring on Attorney Caminero. And he and I are going to talk about a lot of things here today, and I hope to get through them all. And if you feel like anybody would benefit from this information, please share this video with them or subscribe to our YouTube channel where all of our Facebook Lives get updated. Hey, Joel, how's it going?
Hey, good. How are you? Here in sunny Orlando right now.
Can you hear me?
Yeah, can you hear me?
Oh, yeah. Yeah, you're good. Sunny Orlando.
Yep.
And thank you for staying late tonight. I definitely don't pay you to stay after hours, but I know we have a lot of important updates to tell everybody. Yeah. And for those who don't know me or don't know much about our office, we do focus on immigration. It's absolutely our specialty, my expertise. I love immigration law. We also do personal injury and wills, trusts, and estates. But earlier this week, Attorney Joel sent out an email to me, Gloria, and Safat, everybody in the immigration division, to discuss proposed changes to a very important rule. And I appreciate you keeping me up to speed on anything that I might miss. And so, Joel, why don't you tell everybody about the proposed changes, or let's actually take a step back. What is the 601A waiver and what are the proposed changes?
Right. So the Department of Homeland Security and USCIS, they issued a proposed rule change, informational, on their regulation site. So it's basically addressing the 601A waiver. That's specifically what it's going to be looking at. We don't know what they're looking at yet. The proposals are not in detail. So essentially, we don't know what's going to happen given this administration's recent actions toward immigration and the temperament and the environment. It seems a little bit hostile lately, but we'll see as it develops. A 601A waiver is basically a provisional waiver that you would apply here in the U.S. When you are about to travel to the consulate or the embassy to pick up your immigrant visa, your green card, after the interview has been scheduled. And it waives the unlawful presence bar that you have accrued, the unlawful presence you have accrued, so you won't receive the 10-year bar. If you're in this country and you've been here over 1 year, you've accrued unlawful presence for a year, and then you depart the country, you have what's called a 10-year bar. So that's essentially what this waiver would waive.
I'm just going to jump in. This program started back in 2012 or 14 under the Obama administration. In the past, for people who meet this criteria, meaning they're not eligible for adjustment, but there is an immigrant visa available to them, they would have to go to their home country to apply for this waiver, oftentimes being separated from their families for 1 to 2 years, and sometimes permanently if their waivers are never approved. The provisional waiver allowed for people to wait inside the United States. This way, they're not separated from their families. And once it's approved, they travel to their appointment for the sole reason of receiving their immigrant visa. And I know it's really scary for a lot of people who've been here 20, 30 years, because you hear once you leave, you don't come back. And as Joel mentioned, you trigger a bar or a 10-year bar if you've been in the U.S. unlawfully for more than 1 year. But these waivers allow you, they're like a pardon in Spanish, perdón, right? To be forgiven, to come back for your unlawful presence. So this is a really amazing tool that we've used for our clients, where they wait here. The process takes about 6 months to a year. And then once it's approved, we send them home to receive their visa and come back. So Joel, any kind of other penalties or concerns you have for people who are not pursuing a provisional waiver, in your opinion?
Yeah, for our clients that are pursuing them, we have emailed or contacted them asking them to expedite the document collecting process. You have to show certain types of hardships and certain types of documents. For those individuals that have family members that would qualify for a 601A waiver, I would definitely suggest you stop waiting around and at least contact someone and have that discussion to see if your family member would possibly qualify for that waiver. Before, we don't know what's going to happen. This is a proposal to a rule change, and in this administration, like I said, those don't end up well.
And exactly, whenever there's a proposal, it's usually to limit somebody's right or relief. And if it does become law or changes do go into effect, you could, this option that's on the table now may no longer be available. So please, if you're our clients, we've emailed you. We were probably waiting for documents so we can file these cases as soon as possible before anything changes with the 601A waiver. Let me see what else. And sometimes people don't realize that they're not eligible. A lot of people are like, oh, I've been here 20, 30 years, but because I came here as a child without inspection, I can't apply for the green card, even though I have a wife who's American and 5 kids. That's not true. This is what the waiver cures, right? Or you can even use the hardship if your parent is a citizen and you support your parent, you can use the hardship that they would suffer without you. So if you have a qualifying relative like a parent or a spouse, please contact us. We might find a way for you to find legal status in the United States. It's very strange for this waiver. We cannot consider children's hardships. I don't know why that's not important, but believe it or not, that's how the law is written. So we focus on the spouse or the parents, and we try to project the children's hardships onto the parents. So that's just some proposed changes, something to look out for. Joel, last week when I was on the DACA, I guess adrenaline, I was telling everybody to apply if they're eligible, or we knew immediately. Now that things have calmed down and we're not sure the direction of what's going to happen with DACA, what are we telling our clients who are new applicants?
Right. So if you have never filed for DACA and now you are eligible to do so, and now the Supreme Court has ruled for in some part in your favor to leave DACA how it is for now anyway, definitely you need to speak with someone that's knowledgeable again, because if we don't know what USCIS is doing. There has not been any official language suggesting that they will accept it. They can and they should, but we don't know what's going to happen. They could deny it or reject it. And for someone that's undocumented and you submit an application, you've just put yourself in the purview of the government, and they're not really friendly right now. So if you do get a rejection or a denial, it could lead to a notice to appear that could lead you to deportation proceedings. So it's good to know that if that were to happen, what are your, other options? You might be married now. You might qualify for other forms of relief. You might have a citizen or a resident spouse or parent that can petition on your behalf, and you can adjust your status depending on how you entered the country. Those are options that we would have to discuss with these individuals. So I would just say tread lightly and not file any initial DACA right now, unless you specifically talk to someone that's knowledgeable.
Correct. So initial DACA, that's for those who are getting it for the first time, guys. Right. Renewals, if you already have DACA, yes, now is the time to
even
go.
If it's expired, you can just renew.
Yeah.
So even if you let it expire for a few months, a year,
as long as you had it in some point in time and you still meet the requirements and there's no disqualifiers with certain criminal history, you're good to go now. And like I said, not even I said, the president of the United States said they will try again to stop DACA. So it's not if, it's when. So get your applications in, speak to an attorney if you're not under the renewals to see if you're eligible. Joel mentioned if your case gets kicked out, you're under the purview of USCIS. And September of 2018, USCIS issued a new memo stating that they now have authority to issue what's this notice to appear document to initiate deportation or what's properly known as removal proceeding cases. So forget just DACA. If you're filing for a work permit, you shouldn't be filing for. If you're filing for an extension and you don't do it properly, if you're filing for a green card and it gets rejected and you're out of status, you can not only lose your money and lose time, you may find yourself in deportation proceedings. And I'm not here to say the sky is falling, but it kind of is in our area of law. And you need to be careful before you harm yourself and your family, anybody in your application, and find yourself in removal proceedings. That is kind of what leads to our another topic is like an uptick in rejections. Joel, what are we seeing with USCIS and other people who are involved with these filings?
Right. So the rules changed. The public charge rules were implemented around February 14th, I believe. Since then we've had COVID, so we haven't really been receiving a lot of notifications. But recently, we have been communicating with a lot of individuals that have either filed these applications on their own, and again, they possibly or did contract with an agent, a consultant, a paralegal, just someone that's not an attorney. The new public charge application, the I-944, is 20 pages. That might not seem like a lot, but it's not just 20 pages. It's supporting documents that you have to submit with that, which can sometimes be, in excess of 100, 200, 300 pages. It just depends. It's very situational, and it depends on the amount of evidence that you have to submit. And these agents or non-attorneys, they're just not, knowledgeable in this area, and it could prejudice your case.
Yeah, I'm happy you bring up public charge. So public charge is a provision of the law that's been around for decades, but has never really been utilized. Now, are they not utilizing the public charge rule? They kind of weaponized it to prevent individuals from receiving immigrant visas if they believe they are high risk. So high risk to what? High risk means to receiving a benefit from the U.S. government or assistance. So they look at negative factors. Well, what are some of the negative factors? Negative factors are age, if you have poor health, if you don't speak English. Simply applying for the green card is considering a negative factor. So that's kind of one of those damned if you do, damned if you don't situations. It's a negative factor. So when we prepare these 944s, and I know that we probably have 2 or 3 clients watching that we just put in the mail, we need to get credit reports. We need to get your monthly expenses, your monthly income, your tax returns. If any of this is missing, the whole form can be rejected. And if that individual is out of status, as Joel mentioned, you'll find yourself in removal proceedings. And he did mention, this is not something to try with a paralegal or a notario. Guys, there's immigration attorneys with 5, 10, 15, 20 years experience. We have groups on the internet, blogs, and on Facebook. We're all trying to develop and learn with this new, very scary aspect of the law. So please double check your cases. Please get a consultation. It is changing literally weekly, and we want to make sure you're not going to be found in harm's way. We do have some questions that we're going to get to, but believe it or not, we still have some updates to get through. It's been a busy week or so. So we're going to get to these questions later. We're going to talk about E2, some L1, and maybe some even ICE bonds. So for those who are interested, please stay tuned. We're going to get to that after we just talk about this next subject. So here we have the latest travel ban and the latest proclamation. So before we talk about what happened last week, I will touch back to what happened in April. The president signed a proclamation limiting immigrant visas, and that was set to expire June 29, 2020. With this new proclamation that he signed, it automatically extended the April proclamation till December, end of December of this year. So people who are supposed to receive employment-based immigrant visas may be subject to this travel ban. Spouses of LPRs, legal residents, spouses of green card holders would be subject to this travel ban. Spouses of citizens are not. So there are some exceptions if we can demonstrate the need or the urgency or the benefit to the U.S. to this travel ban. And again, it's for those people who are outside, okay? It's banning people from entering. So if you're here and you have an application pending, you don't have to worry about this specific issue. But if you're outside and you're coming, it's here. So now the latest one is about non-immigrant work visas. And in immigration, we have non-immigrant and immigrant. Immigrant's going to be permanent. You're going to get a green card. Non-immigrant is for temporary periods, a little bit self-explanatory. And this one is a proclamation against non-immigrant employment visas. And I'm going to let Joel talk about it.
Right. So the whole basis of this, according to the administration, is to pretty much allow the U.S. workforce to recuperate. And how does the president plan to do that? By restricting non-immigrants from entering the country. That's the alleged basis of it. But it's affecting 3 categories of visas. It's the H1, the L1s, and the J1s. So the H's are generally for like the tech sector. J's are for cultural exchange, physicians, things of that nature. There are exemptions, of course. And then the L's are for intercompany like transfers, things of that nature. And they're accompanying, family members that would have qualified for like a derivative visa, for example. So those are the ones that are being affected right now. Again, there are certain exceptions, even for an H-2A, for example. They have exceptions for people that are working in the food service sector or medical sectors. So, it's really a case-by-case basis, but I think it would affect the majority of qualified candidates that would have been able to obtain these overseas. And those are pretty much the non-immigrant visas that are being affected right now.
So for those who do have visas already issued, you should be fine in theory. And we say that because there might be a travel ban tomorrow or a new proclamation that might affect you. I spoke to somebody this week, and I think their sister's visa was issued maybe 5 days before the proclamation or the immigrant ban. So she actually has the visa and its date is before the ban, so she's okay. Now, so the issue is, are there going to be other bans like CDC bans? Like we had a client in London stuck there because of COVID. And so there might be something else preventing you from returning. So even if you have a visa, even if these don't apply to you and you're not a citizen, please think twice before you travel. I'm begging all my clients, please do not leave if you don't have to. And even if you have to, let's talk about it, because it can have serious repercussions on your life and your applications. So that, I think, covers
traveling altogether, even if you have, time remaining on any visas, because you don't know what's going to happen in the fall. We could get hit by COVID again. That's what the experts are saying. And just if something were to happen and you get stuck out there, you won't be able to renew your visa, and you're pretty much going to be stuck. So
if you're outside and you have a job here or family, how do you get back? And I just think Joel's right. These are uncertain times. Don't get stuck outside for a trip that was not necessary. So we covered the proposed 601A changes, DACA. If you have questions about DACA, please contact us. You can schedule a consultation online or through our website. So I'll just put it here. And now we're going to go ahead and answer some questions that we have received through our website and prior to this live. So one of the first questions we have here, let me get it. This one, can you come back after being deported? Joel, can somebody come back after being deported?
That's a good question. It's also very case specific. Not everyone can come back, but certainly some individuals do qualify and they don't even know it. So there's always a possibility.
So I'm going to explain what he means by depends. Just give some examples. If you're deported simply because you had no relief and you don't have any crimes, then you only would have a deportation bar, meaning you can't come back for 10 years. However, if you were deported for crimes or some type of criminal history, you'll have a unlawful presence bar, a deportation bar, and you'll now have a criminal bar. So we have to evaluate all of these things. If we can find the waiver for the other one, but we can't find one for the criminal, then you might not be coming back. So it is a very case-specific question. There are options, especially if there's family members here. So if you've been removed or deported or you have a family member who has, there may be an option. There's waivers for deportation. There's waivers for even certain criminal history. It just requires an experienced team to help get your family member back here.
Right, and this is based really quick. And remember, there's two types of visas, like Naif mentioned that earlier. If you're trying to come back on a non-immigrant visa, that's a completely different waiver. And it's a lot easier to get that type of waiver if you're not planning to immigrate to the United States, because some people are permanently barred from immigrating and getting their green card. But if you've been removed already, we can certainly perhaps explore other types of non-immigrant visas with a waiver that's available.
So another question we have is, how do I know if I have a deportation order or removal order? For those who are not fluent or experienced to immigration law, believe it or not, millions of people have deportation orders, and I bet you many of them do not know that they have it. I've seen clients go to their green card interviews, and not seen them, but I've seen their spouses, and then their spouse gets arrested because they had a deportation order they didn't know about. There's two ways you can check. There's a phone number for the court, 1-800-898-7180. You press your number 1 and then you enter your A number. If your name is not in the system, it's a good indication that you don't. However, it's not final. We can do what's called a FOIA request, Freedom of Information Act, to see if anything in your name comes up in any of these immigration agencies to actually give you a clear picture. And now for anybody who's been here for a long time, we always recommend what's called the research and investigation or analysis portion of representation, so we can get a full picture of what their immigration history is in order to find options for them. Like, we can't help until we know the full story. So there is a way to check if you have a deportation or a removal order. And if you think you might, then there's probably a reason for it, and you should contact an attorney to help you for that. So do deportation orders expire, Joel?
Again, these are just, I hate to keep repeating it, but it depends, right? So it depends. If you have been given an order of deportation and you never left the U.S., it's still, it's still going to be active. They can, reinstate the deportation order if you're ever detained. If you're ordered removed from the country and you leave, and it's been, past 10 years, that could be a different situation. So it's just very case specific, whether you left or not, whether you're in the U.S., outside the U.S., things of that nature.
And the reason he says if you've left or not is because sometimes somebody will have a removal or deportation order from more than 20 years ago. And they say, well, I heard the penalty's only 10 years. Well, guess what? The penalty doesn't start until you actually leave, right? So sometimes we have to reopen individuals' removal orders or deportation orders to find options for them. And that's possible too. So just because you have a deportation order or a removal order and you're here, we might find options for you, such as Joel loves post-conviction criminal relief. I like motions to reopen to see if there's anything else that we can do to kind of undo the past because your circumstances have changed. And we've done this for people, let's say they came at the age of 14 with their parents applied for asylum, but they lost the asylum case. The entire family receives the removal order. So when the child is now, let's say 30 and married to an American citizen, he or she cannot apply for the green card because of the fact that that removal order is still on that individual. So what we can file an I-130, we can try to get it reopened. So there's a lot of different things that you can do. This question says, can a naturalized citizen be deported or removed?
Same answer. It depends, right? So a citizen cannot be deported or removed, but they can be denaturalized. And then they can be, placed in removal/deportation proceedings.
Right. So cases where they go after people in big federal court cases, if somebody misrepresented on asylum application or a naturalization application, and then they're going to say, okay, well, you committed fraud to obtain your citizenship. So you're going to go through the federal program of or charges where we're going to take it away from you. And this administration has created a task force, you guessed it, to do just that. So now instead of processing applications of people who are filing, and this is such a small percentage of cases that actually they discover, they now have a task force focusing on denaturalizing U.S. citizens. So it is
an example also. It happens a lot with diversity visa applicants that get approved for the diversity visa. They do not mention their children on their underlying applications all the way through their green card. Don't mention their children. They naturalize, don't mention their children, and then after they're citizen, they want to petition for their children. So now USCIS knows that this person has been misrepresenting the fact that they had no children in 2 previous applications for a span of 5-10 years. So
it's a great point. And since we're on the topic of deportations, my friend Mohammed is asking us, hey, Mohammed, I hope you're doing well. Checking the deportation order through the 1-800 number, does it open the eyes on the requester? Some people are scared to check. Very good question. No, it's an automated system where you don't speak to anybody. You just simply enter the A number in. So if you are hesitant, you can contact our office. We can file a FOIA request. And I think Joel has something else he would like to add to that.
We have a banner with the portal. They can also check on the portal, just entering their A number if they want. So
there's also a website portal. You can check. The listing is extremely long. So maybe when we're done, Joel can copy and paste it in the comments, and then you can check the online portal to see if you have a deportation order or not. Again, we do this all the time for our clients. Sometimes they don't know if they've been inspected, right? They don't have proof of a stamp on their passport, but a long time ago, and still today, Canadians come and go without any stamps. There was a time where Mexican citizens were able to come back and forth fairly simply, and we need to determine whether or not they were inspected. So we can do CBP FOIA, right? We can try to figure out, was there any time where they had a visa that was properly issued, So we can use that as circumstantial evidence to prove that they entered legally. So you do have options. If you're not even sure what happened, it was 30 years ago, you didn't speak English and you hired somebody to do something, we can get those records for you. All right. So those are some deportation questions. I'm going to go ahead and jump to E2. We have about 5 more minutes and we will do these E2 questions. The E2 is an investor treaty visa, meaning that the specific countries must have signed a treaty with the United States allowing their citizens to receive investor visas. So what are some examples of the investor visa countries? Spain, Italy, Jordan, Egypt. These are all investor visa countries, for example. There's some countries that you might be surprised that are not, would be like Portugal and Brazil, right? But we do have clients from the UK who are on E2s, Italy and Spain, and it's pretty cool sometimes if you have like Venezuelan clients, they have grandparents who are Italian, we get them Italian citizenship, and then we can get them the Italian E2. So a lot of times when we're asking you a million questions during your consultation, it's to try to determine, are there options that are not available today but might be available down the road through obtaining another nationality. What is the process of the E2 visa? So the E2 visa, you can apply for it after you've invested or while you are in the process of investing in a business enterprise, right? And this can be done inside the United States if you entered on a specific visa on your passport of that treaty country. So I just gave you guys the example of Venezuelans with Italian citizenship. If you enter on the Venezuelan passport, we can't do a change of status for you on that passport. You would have to leave the country, re-enter on the Italian to do a change of status as Italian because you're considered your nationality of the passport that you used. We can also then make appointments at the embassy. And typically the process of creating the E2 visa is showing the source of funds. This is one of the most important things of the investment, where we have to show how did the investor come into this money. And I like to use the example, if somebody owned a piece of land or inherited a piece of land, we would show how they inherited it and then who they sold it to. And we want to show the contract sale of land, the money being transferred, bank accounts, wire transfers, all of this to show that these monies are legal and they were obtained through legal proceeds, okay? So that's one of the requirements. Investing, source of funds, we need a business plan. We need to show how is the investor going to direct the business enterprise. Is this investment substantial? It's not marginal. So these are kind of these formulaic words that we use when we're going through an E2 visa case. Now, typically preparing for one, we would create a package, whether you're here or abroad, and it would have the cover letter, the source of funds, a flow chart of the money, where everything came from, and the business plan, employee charts, and everything. So here in the US, you apply for change of status with USCIS. At the embassy abroad, you would make an appointment and present your case. And that's where it gets a little bit tricky because every embassy is allowed to create their certain criteria for the E2, meaning do they want it in a binder? Do they want it 85 pages or less? Do they want back and forth? You know, Italy and London are famous for their specific requirements. So you do want an attorney who is experienced with doing consular processing, so they are aware of the different requirements for that country. All right. E2 visa, how long does it take? So if you're in the US, you can pay for premium processing. That typically would allow us to get a decision within 15 days. But more likely than not, within 15 days, you'll probably receive a different correspondence, which is like a request for evidence or, or some other need of the documents. They have to give you a response within 15 days, not a decision. So for the consular process, it all depends on the embassy or the consulate's wait times. If there's not an appointment for 4 or 5 months, guess what? You're going to wait until your appointment comes due. So sometimes that's an important factor when determining, are we going to do change of status or are we going to do consular process? All right. Is the U.S. visa embassy going to open soon for scheduled interviews? I did see we are starting to get more notifications from the NVC. This is a question here that I received. I'll just post it. Thanks, Shahida. How are you, by the way? It's good. I'm glad you tuned in. So thank you for your support, as always. The embassies are starting to reopen. There's not an official announcement that they're all going to start at a specific date, but we have started to receive correspondence from the National Visa Center saying that they have received all the documents. I believe some interviews have been set, but we don't have official word on that yet. So I'm going to jump back to E2. Sorry, Joel. No, it's my territory here. And possible questions during the E2 visa interview. This is probably going to be about the source of funds, education, experience. Sometimes they want to test the knowledge of the investor to see, do they have the capacity or the experience to run the business they say they're going to run. You know, was this just paper they filed so they can get a visa, or do they actually know the ins and outs of their proposed visas? So be sure to know your E2 visa case from page to page and to know your business. All right. Advantages and disadvantages of the E2. For advantages, for sure, it's a low investment amount. It can be, I mean, I think one time we did it at like $38,000. I don't recommend that by any means. But sometimes when the clients want to try that, I give them the warnings and we try. And it, alhamdulillah, thank God it was approved. But this was different times now. So another advantage besides the low investment amount is going to be the premium processing. How quick can you actually obtain the visa, as opposed to an EB-5, which might take 1.5 years or 2 years to be processed. Downfalls. E2 visas on their face and as the law is written does not lead to a permanent residency. Also, E2 visas differ from country to country. This is another disadvantage about how many times you can enter on your E2 visa. For example, Egypt is a single entry 3-month visa, which means you have, after the approval of your visa in Cairo, you have 3 months to get to the United States. Once you enter the United States, you have 2-year status in the E2 visa, and you can continue to extend your status. However, if you travel back to Egypt to visit mom, you're going to have to go through the consulate or the embassy again to get restamped just so you can come back, unlike the multiple entry B1, B2 visa. So I would say that's a downfall. Another downfall, or it's a positive at first, it gives the benefit to your spouse, your husband or wife, to work in they'll get a work authorization. It allows you to bring your children. However, your children, this is where it becomes disadvantage, over the age of 21 would fall out of status. All right, I'm going to just do one more E2. Are my children going to be forced to leave from the United States after they become 21? No, but they could be forced if they don't find a solution. So prior to your child becoming 21, we need to possibly look into getting an E2 of their own, changing their status to an F1, which is an international student. So if they do not change their status properly, then once they become 21, immediately they start to accrue unlawful presence. So if they don't have any status after 1 day of their 21st birthday, they're out of status, accumulating unlawful presence. So make sure you go ahead and start to plan ahead of your child's 21st birthday. Joel, is there anything you want to add before we go?
I think we covered pretty much all the updates and topics of interest. So I think we're good for the most part.
I just want to reiterate that last week we announced our of counsel estate planning, will, trust, estates, living wills and wishes. It's really critical with this, crazy times. God forbid something happens. You have a document that describes to medical professionals how you want to be taken care of, or who can make decisions if you're incapacitated or not. That's something we talked about last week. This video will be uploaded on YouTube. So if you could please like and subscribe to our YouTube channel, I would appreciate it very much. And share this, and we will be here next Thursday, same time. And I want to thank Joel again for staying tonight and for really working hard on staying up to date on all the changes that are constantly happening. And again, next time, email me your questions ahead of time, and we will make sure to address it at the next Facebook Live.
You guys have a good day.
Thank you. Have a good night, guys.